All right. Well, welcome everyone. Thank you for joining us for our virtual IP Bootcamp, which is part of our innovation series here at the Carlsen Center for Innovation and Entrepreneurship at Sac State. My name is Cameron Law. I serve as the executive director of the Carlsen Center, and we're on this mission to turn this region into a premier hub for innovation and entrepreneurship. And we really serve as a platform to enable startup founders of all backgrounds to start and scale their businesses. And we're excited to bring to you this bootcamp to empower you and ultimately help you protect your ideas, inventions, and trademarks and galore. But we have an awesome workshop, actually two sets of workshops for you here. And I'd love to turn it over to our partner who's been helping us in putting this IP Bootcamp on. I'll turn it over to Raphael from the Office of Innovation and Technology Transfer, who will introduce our workshop lead here today. But take it away, Raphael, and thank you all for joining us.
Good day. Thank you all for attending. I'm with the Office of Innovation and Technology Transfer. I joined Sac State 22 months ago to set up this office. Before that, I was with the University of Hawaii for 3 years in their tech transfer office, and before that with the UC Davis tech transfer office for 19 years. The mission of our tech transfer office here is to manage, protect, and commercialize Sacramento State intellectual property to benefit California and the world. Also to educate faculty, staff, and students about intellectual property and to encourage them to invent, create, and innovate. So with that said, I'd like to present to you Dr. Lawyer James Ritchey. Take it from here, sir.
All right. Good afternoon. I'll give you a little bit of background for me to begin with. I received a Bachelor of Science degree in chemistry at the University of Redlands, which is a small private school in Southern California. And then I took a year's leave and was a quality control chemist for Schilling Spice Company in Salinas, California. And then I proceeded on to graduate school at Northwestern University, just north of Chicago in the city of Evanston, and received a master's and Ph.D. in biochemistry. I then came back to California. Not that I don't like Chicago, but the weather's a little different than California. And then in California, I was a National Institutes of Health, NIH, postdoctoral fellow in molecular biology at the University of California in Berkeley. And from there, I was hired at Sac State as a professor of biochemistry, biochemistry. And for 45 years,
Jim, you accidentally got muted. Apologies. There you are.
Okay. A couple of years ago, I retired from Sac State, and I am now an emeritus professor at CSUS. I'm also an advisor to the Office of Innovation and Technology Transfer. In addition to that, I'm also president of a startup company, CR Flight. We specialize in high-tech, high-efficiency, high-thrust electric counter-rotating motors for drones, automobiles, boats, various types of vehicles. And I'm also a partner in the intellectual property law firm of O'Banion and Ritchey. We have our offices in downtown Sacramento. Now, if you notice here on the PowerPoint, I've got two web pages down here where you can contact me if you have any questions, jmr@intellectual.com or ritchie@csus.edu. All right, so for today's boot camp, we're going to be talking about intellectual property law. Now, today we're going to be focusing on one area of that, which deals with patent law. Tomorrow, we'll move into the three other areas of intellectual property law. All right. Oh, I should mention also that for the 45 years that I taught chemistry at Sac State, for 15 of those years, I was also an adjunct professor of law at McGeorge Law School and taught intellectual property law and patent law at the law school. All right. Now, as far as intellectual property law is concerned, almost all projects in intellectual property law start with an idea, and that idea gets developed to the point where it actually creates money for the person who came up with the idea. Now, unfortunately, the pathway from the idea to creating money is not a nice, smooth, one-step course. What we've got here, first of all, are the 4 areas that are covered by intellectual property law: patents, copyrights, trademarks, and trade secrets. And as I indicated, today we'll be dealing with patents, tomorrow we'll be dealing with copyrights, trademarks, and trade secrets. But if you have an idea in any of these areas, whether it's an idea for a new mousetrap, a new invention, or you have an idea for a new novel or a new movie picture, whatever it happens to be, you want to proceed as quickly as possible from the idea to the point at which you can actually have some earnings coming in. Now, that pathway is often really a minefield that you have to go through. You have an idea, you have profits down here, but it's never a straight line. There are always difficulties, and let's say you want a patent, in obtaining the patent. There's also a million problems in marketing your device in order for you to finally end up generating money from that idea. Now, take, for example, this is a theoretical picture here, but a few years ago, this is an example of a real-life case for the company Affymetrix in the center here. And Affymetrix created an invention that was called the gene chip. And the gene chip was a little device that was used to help sequence DNA, figure out what the nucleotide bases were in the sequence. And they had 400 issued or pending patents. And it was an extremely hot area for work, the Genome Project. There were a lot of other companies who were also inventing in that same area. And these various companies had their own patent applications, their own issued patents. And in order for Affymetrix to get to a final point at which the gene chip would be profitable, they had to make sure that they weren't stepping on the toes of all these other companies' patents. And that was a very complex process. The gene chip is still around and it's still making money for Affymetrix, but it was not an easy process to get from the idea of the gene chip to the final point at which it was drawing in money for the company. All right, now what exactly is intellectual property? Well, it is really the opposite of tangible property. What's tangible property? Tangible property would be your house, the land that your house is on, a washing machine, your automobile. Those are tangible properties. Intangible properties are basically properties that are created from ideas. And you have, as I indicated on the previous slide, trade secrets, trademarks, copyrights, and patents that involve protection schemes for protecting intellectual property. Now, you have to think, first of all, for intellectual property really goes to ideas. So you can ask yourself a question, and that is, do the remedies for theft of these two kinds of property differ? All right, so if you have your car stolen, what's going to happen? Well, you're going to report it. The police are going to try to find it. Hopefully they find it. They bring it back to you, hopefully in one piece, and you get your property back. But when it's stolen, you don't have the physical object. All right, that's different than intellectual property. Take, for example, this picture right here, where you've got Neanderthals over here, another one over here. And what these Neanderthals are saying to each other is, hey, look what Zog do. All right, Zog has a new invention. He has invented a way to cook meat by putting the meat on the end of a stick. The other Neanderthals are still trying to cook meat by holding it in their hands. All right, well, Zog has an invention. It's a stick used for cooking meat. All right, so if these three Neanderthals go out and cut their own sticks and use them, they have stolen the idea that Zog had. The difference here between that and the theft of an automobile, let's say, is that Zog still has his stick. He is still able to use his invention. He's not deprived of it, but if Zog wants to get into the business of selling sticks to other Neanderthals, then he's going to have a problem because the other three individuals have their sticks and they can start selling them too. All right, so the method that the result of theft differs drastically between tangible property and intangible property. All right, so for patents now. Technically, the term for receiving a patent from the US government is called a letters patent. And it's an intangible property right granted and regulated by the federal government or equivalent entity in each country. And that's something that's very important. When patents are granted, a patent is only valid in the country in which it is issued. So the US government issues a patent. It's only valid in the United States, the territories, etc., of the United States. If you want a patent in Germany, you've got to file through the German government. If you want to file in France, you have to file through the French government. All right. Now, the rights that are granted allow you to prevent others from making, using, or selling a patented invention. It also allows you to have the customs office in the United States seize imported goods and destroy them. If they interfere, they infringe your patent. All right, so you have the right to prevent others from making, using, or selling. Now, the government's not going to enforce those rights. You have to go to court to actually enforce those rights. All right, now you might ask yourself, why obtain a patent? Well, one reason is to prevent others from making, using, or selling the invention. All right, that's what I just mentioned. Another is you want to generate income from licensing or selling your invention to other peoples or companies. You also want to perhaps generate what is called a patent portfolio for litigation or negotiation. Sometimes if you're with a company and you might have 10 patents in a particular area, and you are competing with another company, maybe the other company has 10 patents, different patents in the same area, and you realize that in order to be profitable in whatever the invention happens to be, maybe it would be useful to have some of the other patents, the ones from the other company, and you should be able to use those without being charged exorbitant fees. Well, you can negotiate back and forth. You can trade. You can say, well, the other company can use such and such of our patents, and we can use such and such of your patents, and we're not going to end up in court in a litigation suit. So you create a patent portfolio, and you can use that for litigation or negotiation purposes. You can also protect against others obtaining a restrictive patent. So maybe your technology has a number of different areas in it, and one of them happens to be an area that you don't have a direct patent in. Well, if you then obtain a patent in that area, you can prevent others from maybe getting a patent in that area and not allowing you to proceed in that area. Marketing strategies and public relations are also very, you use patents for those areas also for marketing strategies and public relations. As I mentioned before, you can also have customs collect and destroy infringing items that get imported into the United States. And the last one down here, it's always impressive to have a patent framed for your office wall. I actually had one client who came in at one point and had a device that it was a very fancy stainless steel device. It was about the size of an old-fashioned computer, and the whole purpose of the device was to make kindling out of small pieces of wood. And I pointed out to him that you can use a hatchet to do the same thing, and it's a whole lot less expensive than buying your $5,000 kindling maker. He didn't care. He wanted to have a patent for his wall. So we did that. I don't think he ever sold any of his devices, but he had a nice patent to frame for his wall. All right, now the basis for protection, for patent protection, you have federal statutory reasons for a patent. And the actual basic foundation for patents come from the original federal Constitution. Article 1, Section 8 provides protection for inventors and their inventions. Also, you find the details to patent law in 35 USC, United States Code, or 37 CFR, Code of Federal Registry, for the detailed steps in how patents are applied for, how they're analyzed by the examiners in the patent office. All right, so the details are found in those two sources. And then there's also non-statutory basis for U.S. patent rights, and they come from case laws. Usually the case laws are decided in the 10th Circuit or the Supreme Court, and those are also looked to for the basis for protection for patents. Now, in patent law, there are three basic types of patents that are out there. There is the utility patent, there is the design patent, and there is the plant patent. And they are a monopoly. They prevent others from making, using, or selling for different periods of time. A utility patent has a 20-year life from the date that it is filed. It used to be a few years ago that it was 17 years from the date of issuing of the patent, but that got changed to 20 years from the date of filing. A design patent, now, by the way, a utility patent goes to how something functions, and we'll get into the details of that shortly. A design patent goes to the surface ornamentality of an object, and it has a different life. It has 15 years from the date of the grant of the patent. And then a plant patent is a very limited type of patent. It's not used by too many individuals or corporations, but it's on a special type of plant. I'll mention what that is in a minute. And it's 20 years from the date of filing also. So those are the three types of patents that are out there. I'm going to go into utility patents in a lot of detail shortly, but I want to go through design and plant patents first of all. All right, so for a design patent, whoever invents a novel, useful, and non-obvious ornamental design of a functional object can obtain a patent subject to 35 U.S.C. 171 for an ornamental design. Now, it goes only to the surface ornamentality, and that means that it is basically extremely limited. You can make minor changes in the design and get around an issued design patent. All right, so examples of design patents. There are design patents on cell phones. Apple Inc. has a design patent on their iPhone, their smartphone. Computer icons, such as various emojis, have design patents on them. Fashion accessories, hats, jewelry pieces, purses, furniture, chairs, lampshades, etc. Also, other objects like a bottle, a Coca-Cola bottle, had a design patent on it many years ago that's expired, but there was a design patent on the Coca-Cola bottle. On monuments, the Statue of Liberty is an example of that. All right, now design patents only protect an object's ornamental appearance. They do not protect the object's structure or utility. You need to have a utility patent for that to occur. All right, they expire 15 years after the date the patent is granted. It used to be 14 years, but that was changed. And if you had a patent that was filed before May 13th, 2014, you had a different life. But currently, it's 15 years after the date the patent is granted. You must have permission of the owner of a design patent before you can use, sell, offer to sell, make, copy, or import into the U.S. the object that is substantially similar to design claimed in the design patent. Now, the legal fees for obtaining a design patent are somewhere between $1,500 and $3,000 usually. They're a much simpler patent application than what you'd have for a utility patent application. A utility patent application is basically a scientific paper with a number of what are called claims attached to it. It's much more difficult to prepare. It's much more extensive. All right. As I said above, many objects can also be protected not only through design patents, but the Coca-Cola bottle also had trademark law and trade dress for protection. Statue of Liberty also could be protected under copyright law. So sometimes you have multiple ways of protecting various items. All right, this happens to be the cover page from the design patent that was issued in 1915 for a Coke bottle. And the cover page is created by the patent office from data that's set in by the applicant. They take the information that's sent in and create this cover page. Usually for a design patent, it's a very simple cover page. And here what we've got is the name, you've got the inventor, you've got the patent number and the issue date here, you've got the claim. It says, I claim the ornamental design for a bottle or similar article as shown. And then you have figures. In this case, you only need 2 views to see what the complete figure looks like. And then that's the issued patent that you get. All right, so if the ornamentality of that bottle changes, say the bottom balloons out, that's probably not going to be covered by this design patent. All right, and as I mentioned before, the Statue of Liberty also had a design patent, and that was issued in 1879, obviously expired a long time ago, but that's the type of thing that you could have for statues and that type of thing also. All right, now for plant patents, that's one of the other 3 types of patents that you can have. Whoever invents a new and distinctive plant can obtain a patent subject to 35 U.S.C. 161 on such a plant that is, now it has to be a special type, not a tuber propagated plant such as potatoes or yams, invented or discovered in a cultivated state, and asexually reproduced. In other words, without seeds, such as by budding, cutting, grafting, and spores. All right, it requires asexual reproduction to prove that the patent application can reproduce the plant. And it expires after 20 years from filing. Now, this is an extremely not very often used patent. And most of the time, if you were, let's say, the University of California, Davis, or Riverside, or maybe CSU, Fresno, where you're doing a lot of plant research, perhaps you'd have plant patents that they have to worry about. Or if you're an agri corporation, then you'd be worried about plant patents. But they're a fairly rare situation. Most of the time, what you're dealing with in patent law deals with utility patents, sometimes design patents. By the way, when you see often on television or streaming, you see ads from companies that are offering to get you a patent on your idea. Well, usually the patents that they're generating are design patents, not utility patents. And as I said, design patents are very easy to get around. It's not difficult at all to make a slight ornamental change. The design patents are usually used for something that the public really wants. If you've got a 2020 Toyota car and the bumper is somehow damaged and you want a new bumper, well, you want a bumper that looks like the original one. And so automobile companies very frequently get design patents on different parts of their cars, like a bumper, so that no one can reproduce their bumpers without having permission from the company. All right, now for the major area in patent law, we have what are called utility patents. And patent law is designed to encourage inventors to disclose their new inventions to the world in exchange for a time-limited period of monopoly to exclude others, as I've indicated before, from making, using, or selling, offering for sale, importing, inducing others to infringe, or offering a product similarly adapted for practicing the patented invention. So you've got rights that are obtained by receiving a patent from the US government. It expires, as I've indicated, 20 years from the filing date. Sometimes that can be extended. Take, for example, if you come up with a new type of drug and the FDA, in order for that drug to be allowed to be used in the public, has to be tested. And maybe it takes 4, 5, 6 years of testing by the FDA before it's allowed to go into the general public. Well, that time can be added on to the patent. So that 20 years is not an absolute date in certain situations. All right. In order for the USPTO, which is the United States Patent and Trademark Office, to grant a utility patent on an invention, the invention must be, it has to be useful. It has to do something in the real world. It has to be novel. It can't be a duplicate of something that's already out there. And it also has to be non-obvious to a person skilled in the relevant art. So a person skilled in the relevant art, if, let's say, the inventor of this new device has a Ph.D. in physics, then a skilled person, an ordinary person skilled in the art, they'd be considered to have a Ph.D. in physics. All right, so those have to be true. Now, statutory allowed categories for a utility patent. There are certain items that can be patented under a utility patent. First of all, a machine can be patented, a new and useful machine. All right. Second, a manufacture. Now, that's the technical word that appears in patent law. Manufacture is the same thing as a product. All right, so manufacture, read product, can also be patented. Now, in a patent, you can only have one invention. You can't have multiple inventions, and I'll come back to that a little bit later. You might have multiple inventions that you filed in a patent application, but the patent application is only going to be granted to one of those inventions. All right, another category deals with a process or method of doing something. An additional area, composition of matter, basically a chemical composition. And also improvements to any of the above, the 4 topics above. If any of those are improved, you can receive another patent on those. All right, now the requirements for patentability, and you find those in 35 USC, as I indicated, are utility, novelty, non-obviousness, and also there are other considerations that you need to worry about. The claimed invention is actually in the hand of the inventor at the time of filing, is claimed in sufficiently clear and concise manner, and is enabled. In other words, it allows someone else to reproduce the invention, whatever it is, and includes the best mode for practicing the claimed invention. You can't hide your best mode and at the time of filing, try to get a patent on something that does not have the best mode in there. And you have to have the best mode or the entire patent can be invalidated. I had that actually happen once when I was first learning patent law. I was an intern with Townsend & Townsend, a large patent firm in San Francisco, and I was working on a patent, learning how to be a patent attorney. And in my notes, I had the data for a new way of purifying antibodies. And there were a couple of ways that the inventor had to purify these. And it eventually had an issued patent by the overseeing attorney who was overseeing my work that did not include the best mode. 10 years later, that got into court and the entire patent was invalidated because the best mode was not disclosed in the original application because the inventor knew about it at the time of the application. All right. Now, these are examples of different actual issued patents. Now, these are somewhat humorous, which is why I put them in here. This, again, is what's called the cover page for a patent that's issued. These are actually issued patents. All right. And this one was for a hay fragrance. This is an issued patent. And what you've got here, the inventor, it's filed right here. The issue date is up here. And it used to be 17 years from the date of issue. So you'd look at that date up there to see what the life was for the device. And then you have an abstract. An abstract has to be written in clear and concise language, not in detailed scientific language, so that anyone reading can decide what this particular invention covers. Down below, you see that there are 19 claims that were written for this. The claim is the deed to your property. And it has to be written, as I'll get into later, in concise language. And there are no drawings with this. Usually there are drawings or figures that are included in these applications. All right, so this is one example. Another example of a somewhat silly patent is a helmet here that actually has plants growing in it, presumably to increase the oxygen level for the individual wearing the helmet, but it doesn't seem like it would be very practical, but again, it is an issued patent this figure came from. Here's another example of a cigarette that actually is cheese flavored. So cheese is mixed with the charcoal. You inhale and it tastes like a stick of cheese, I suppose. All right, here is another example of a figure from an issued patent where you have additional washing devices that are added to the rim of a toilet. Okay, utility patents, patent eligibility. There are various things that cannot be patented, and they are usually excluded from patent protection by public policy decisions. One, abstract ideas such as mathematical equations and scientific principles cannot be patented. Laws of nature, such as gravity, electromagnetism, cannot be patented. They're excluded from patent protection. And then natural phenomenon, including products of nature, such as isolated DNA. Now, you could protect modified DNA, where you have isolated DNA and chemically modified it. That's okay for protection, but isolated DNA that normally exists in a cell, that's excluded from protection these days. Cloned farm animals such as cattle, goats, and sheep, they're not eligible. Correlations that result from, let's say, consequences of a compound being metabolized in the body, those are not patentable. And anything about human beings are not patentable. That's off limits. And nuclear weapons and other weapons of mass destruction are not able to be patented. When you file a patent application, you send an application off to, usually electronically or through the mail, snail mail. When you file a patent application, the first thing that's done is that it's examined for national security matters, whether or not you're claiming a nuclear weapon, that type of thing, or whether or not you're claiming a new type of rocket fuel that could actually be used for a real rocket. Those sometimes have security clamp down on them. And in a lot of cases, they'll never issue as a patent. They're viewed as too important for national security to be allowed out in the general public. All right, and also down at the bottom here, anything that has been previously public disclosed, this is considered prior art. All right, and prior art is never patentable. If it is out in the general public knows about it, it's not patentable. All right, now, there are certain different types of patent applications. First of all, the simplest type of patent application is what is called a provisional patent application. A provisional patent application is never itself examined by an examiner in the patent office. It's only a placeholder. It's relatively inexpensive to file, a little over $100 to file, and it has to have all of the information necessary to enable your invention, but it only has a year life. And then before that year is up, it has to be converted into an original application. And then the original application is actually examined by an examiner. All right, so a provisional application, very inexpensive to do, and it usually just keeps a beginning date, because remember, your life of your patent begins from the date at which you file it, which would be the provisional filing date. All right, there are also what are called divisional applications. Sometimes you have more than one invention that's disclosed in a patent application. And the examiner, when they review the patent, write up what's called an office action. And in that office action, they'll force an election on you. In other words, you're only allowed one invention per patent application. And so they say, you're going to be forced to only have these particular claims in this patent application. Now, that doesn't mean that you are excluded from the other inventions that you've disclosed in that patent application. What you can file in each of those is a divisional application. So you have to repay the filing fees, etc. And then you've got a second case going on the second invention, or third or fourth. And the reasons why you might want to disclose more than one invention and then separate them out into separate applications that are each prosecuted individually. All right, there's also what's called a continuation in part. When you have a patent application, the timing starts from the date that it's filed. You can't add to that application once you filed it any what's called new matter, any additional new information. And if you do, then that's called a continuation in part application. And what that does for any additional claims that are put in there because of the new matter starts a new date. It's not the original filing date, it's the date that the new matter was added. There's also what is termed a request for continued examination. Sometimes you get through the examination process with the examiner. Now, the examiner gets to file an office action. And in that office action, usually when it's returned to the applicant, 90% of the time, the claims, the deed to your property, are rejected for whatever reason the examiner gives. Usually it's based on prior art, because the first thing the examiner is going to do after checking for security matters is to do a search. And if they find documents that they believe that your patent reads on, then they're going to reject the claims based on those prior art references. All right. And they file an office action, then you are allowed to file a response to that, where you write back and you basically argue that you respectfully say the examiner is incorrect for whatever reason. You don't think the prior art references have been applied correctly. And then the office, the examiner in the office, gets to file another office action. And that second office action, it has the right to be what's called a final office action, where all of your claims or some of your claims might be rejected, some of your claims might be allowed. But they file a second office action back to you. And then once you receive that, let's say all of your claims were rejected. Well, you have a number of options once all the claims have been rejected. You can appeal to a 3-panel person in the patent office, or you can basically try to get another bite at the apple by filing what's called a request for continued examination. You basically pay a second application fee and you submit an amendment arguments as to why the examiner is still incorrect in their opinion. And then the whole case gets reheard. The examiner goes through the whole process again. That's a request for continuing examination. All right. There's also what's called a substitute application. And a substitute application is basically, you've discovered that your original application is basically worthless. It doesn't enable your invention, and you have to start over from scratch. And that's called a substitute application. And you have new dates associated with filing it. All right. Now, if you're going to be filing in more than the United States, if you're going to try to get international protection, one of the best ways to do that, you could file directly in each one of the foreign countries that you want protection in, but a better way to do that is to use what's called the Patent Cooperation Treaty, the PCT. And it's a system that's run by WIPO, the World Intellectual Property Organization, and there are 153 countries that are a member of this group. And what you do is you file an application, PCT application, and you could designate the United States within a PCT application as just being one of the designated states. And then in 18 months, you have to actually designate what countries you want to be serious about and actually go forward into the national phase. When you go into the national phase in other countries, you have to hire an attorney to process the patent application who is allowed to practice in that country. All right, so with my company that I'm president of, we have a number of issued international patent applications, and they're processed by individuals who are actually licensed in the various countries where they are issued. All right, so what that allows you to do, though, is initially file only a single application and then worry about switching over to national phases later. All right. Now, to protect your IP rights, you want to have a number of things that you worry about. You do not make a public enabling disclosure before filing a patent application. All right, what's an enabling disclosure? A disclosure that contains sufficient information and detail to enable someone skilled in the art to practice the invention. Before making a public enabling disclosure, you should talk with an attorney or the Office of Innovation and Technology Transfer to figure out the timing. Because once you've made a disclosure, you have to worry about the fact that in the United States, you've got a year window to make a patent application, but that's not true in most foreign countries. All right, you also have to worry about not selling or even offering for sale your invention before you file the patent application, because that's considered a public disclosure. And you do not publicly use your invention before filing a patent application. If you do any of those things, you will lose the ability to obtain a patent in most countries except for the US. You've got a year grace window. Australia, Canada, and Japan, they all have 12-month grace periods in order to file a patent application. In the United Kingdom and the European Union, the EU, you've got a 6-month grace period. If you miss that window, you can't receive a patent on it. All right. Now, examples of possible enabling disclosures. Clients are always wondering, if I do this, is that a public disclosure? If I do that, is that a public disclosure? Well, all of these are considered to be public disclosures. Discussing your invention with people, including family, friends, and colleagues. That could be a public disclosure. Demonstrating, presenting, or discussing your invention at a conference, capstone course, trade show, pitch competition, or other public venue. Publishing an article or manuscript describing your invention in detail so that someone can practice that invention. Posting a description of your invention on the internet. Displaying a poster describing your invention in a government grant application, defending a thesis that describes your invention. All of those can be public disclosures, including selling and offering for sale your invention. All right, so you need to protect your IP rights. Now, if you want to not have a public disclosure occur, you can use some of these techniques. You can use to protect ideas, information, including information about the invention, data. You can use what's called a non-disclosure agreement, an NDA. You can sign that with an individual, and then that material is not considered to be a public disclosure. Same thing with data. You can use a data use agreement, or same thing with physical materials. You can use a material transfer agreement. Those all take out of the realm of public disclosure the items that you're dealing with in these various documents. All right, now to get back to patent eligibility. First of all, you have to have utility. It has to be useful in the real world. An invention must be a process, machine, manufacture, or composition of matter, or an improvement that is useful or has utility that is specific, substantial, and credible. Now, most of the time, examiners are not going to reject you based on a utility rejection. A utility rejection is found in 35 U.S.C. 101. Most of the time, if a patent application is filed, it's because it actually does something. So it has utility associated with it. The second possibility is novelty, which is in 35 U.S.C. 102. And an invention must be novel and not identical to an existing item. So sometimes you will get an office action back from an examiner, and they'll make rejections to the claims based on 35 U.S.C. 102 novelty. And the key here is that for that reference to be appropriate, it has to disclose the exact invention within the 4 corners of the document. If your exact invention is not disclosed, then that's not a proper reference. And in the response to the office action, you would point out to the examiner that the document that was cited does not contain an exact copy of the invention. And then the hardest one here, especially with a rejection that you receive from an examiner, is the non-obviousness difficulty. And that's in 35 U.S.C. 103. An invention cannot be obvious to a person having ordinary skill in the technology. A patent examiner can deny an application for a patent if an invention would have been obvious over what has been described in the prior art. And the key here is that the prior art consists of multiple documents, not just one document like you'd have for a 102 novelty rejection, but multiple documents can be combined. And this is a very hard area because basically the examiner is being a Monday morning quarterback. You know what's been applied for, you know what's in the prior art, and it's Monday morning, and you can guess the result of what the results in the game, right? So what you've got here is a test that's used, and it's a test for non-obviousness that originally came from a case that had the John Deere Corporation in it, but it's called the Teaching Suggestive Motivation Test. And one rationale for determining if a claimed invention is obvious and therefore not patentable. And this is where, when you go from one court to another court, from one region to another region of the country, you have courts that interpret this in different ways. So this is a really difficult situation when you've got obviousness that you have to worry about. According to the test, a claimed invention is obvious when there is a teaching, suggestion, or motivation to combine the prior art into the invention that you've come up with. All right. So a patent examiner can deny an application for a patent if an answer is yes to any of the following questions. Is the invention taught by the prior art? Is the invention suggested by the prior art? Is the invention motivated by the prior art? All right, inventions that fall within the statutory allowed categories for a patent are these that I've listed before. All right, for a machine, what's an example of the types of things that would fall under the category of being a machine? Well, these are somewhat silly to a certain extent, but you could have a golf ball core unwinding machine. You could have computer hardware, terabit hard drive with voice DNA recognition capabilities, optical character recognition minimizer, automatic sampler scrambler, disposable photocopy machine, and a manufacturer. Now, remember, when you see manufacturer, that means product. You could have a portable fish scaling stool, spill-proof round bottom flask, anti-counterfeiting lamination plastic, a suitable medium having an encoded program, computer program, a computer readable disk having encoded upon it a method for calculating proteomic distributions for now known or later discovered biospecies, comprising the steps of, etc. For a process or method of doing something, examples might be monoclonal antibody purification process, a computer program having a real-world use. It can't be a theoretical computer program, a method for evaluating current statistics for SNPs in California purple porcupines, use for a new or old composition. Take, for example, acyluse, a medical regimen for preventing prion proliferation by microinjections of WD-40. That's a new use of an old material, WD-40. Now, compositions of matter, chemical or biospecies, aspirin, that's a typical, that was patented by the Bayer Corporation many, many years ago. A polynucleotide sequence is shown in sequence ID1. And the way these are presented is that you have in a figure sequence ID1, and then you refer to it in the claim. One or more monoclonal antibodies for detecting grant funds, uranium, plutonium derivatives of polyfluorinated ELF genes, whatever that happens to be, and then an improvement of the above. Instead of just aspirin, now it's buffered aspirin. An improved monoclonal antibody purification process. An improved polynucleotide sequence is shown in sequence ID1, wherein every fifth adenine is steroid modified. An improved set of one or more antibodies. So those are all examples of improvements on existing patents that are out there. All right, now this is actually what a patent looks like when you receive a letters patent from the government office. Now, these days, the gold seal is still there, but they don't include the red ribbon anymore. They, I guess, are saving money by not doing that. But that's basically what it looks like. And this, again, is a cover page from a typical patent, utility patent, where you've got at the top the inventor, Finkel. You've got the date of the patent over here, 2016. What you need, though, for the life is down here when it was filed, September 30th in 2013. So the life runs from the filing date down here. This, again, is submitted by the examiner and also by the applicant. These are the various areas that were searched, documents that were found. And then in here, you've got the primary examiner, the attorney or law firm, and then the abstract. And then down here, what the examiner does is once the patent has been allowed, they'll say, okay, which figure would you like to go on the cover page? They'll ask the applicant that, and then you can request a particular figure to go on the application page. Most of the time, the examiner accepts that. Sometimes if they don't like it, they'll pick a different figure, but that's the figure that appears here. And then listed here, it's got 8 claims and 41 drawing sheets. Huge number of drawing sheets in this particular application. So that's what a cover sheet looks like. Now, Cameron, can you, let's see here, I need to have my camera here. I need to have this up on the screen. Can you switch to that?
Yep. Give me 1 second. I will stop your share and pin your video for everyone. All right.
Yeah, that
There
one
you
right
are.
there. Okay, so this is a current letters patent. As I said, you still have the gold seal. You don't have the ribbons on them anymore. And this is for a patent that I wrote for the company that I'm associated with. And here, as you see, you've got the inventor at the top. You've got the date of the patent here. You've got the patent number, which is right above it. There's a barcode that has all this information in it up here. Then you've got the title for the invention. You have the applicant, you have the inventor, usually the applicant and the inventor are the same person, and then the assignee, and this was assigned by Randall Wishart to CR Flight. So this company right here actually owns the patent, but the patent application has to be filed in the name of the applicant, all right? Even though CR Flight owns it, it had to be filed in the name of the original applicant. And then down here, you've got various search areas. You've got various documents that were found over here. Here you've got the primary examiner, the attorney, agent, or firm, James Ritchey, me in this case, and then the abstract. The abstract has to be shorter than 120 words, and it has to be in common language so that someone can understand what the invention actually is. All right, and then down below, what we've got is a figure, and here is the figure that I suggested be put into the cover page, and it's a picture of the counter-rotating motor. All right, and then afterwards in the patent application, what you've got, anything that continues from the first page up here, more documents that were found. And then what we've got are all of the pages that have the figures. Figure 1, that was the one that was on the cover sheet. And then more detailed pictures here of the invention. And all of the component parts have to be numbered because those numbers appear in the description, the verbal description later on in the patent application. All right, so there happens to be that figure 2. This is another one that shows components within the device itself. And then in this particular case, there was a lot of data that needed to be presented to support that this device actually functioned, that it actually worked, that it actually performed as claimed. And so here we've got a number of figures, figure 5, 7, all the way up to figure, let's see, what is it? It goes up to figure 14, I think. Yeah, figure 14. That's all data that's been presented. Now, data can also be presented in figures within the actual body of the specification of the patent application. All right, so after all of the figures are presented, what you have then is the beginning of the patent application, where you've got the name, a number of boilerplate things that have to be put in, and then you put in background. Background is to inform the examiner of exactly the area in which your invention rests. All right, and in that process, we've got here the technical field, the background, and then we have over here the various figures are described, the figures that appeared earlier, and then we've got the detailed description of the invention. And that's where all of the numbers and component parts have to be listed and described exactly how they function. There are also data tables that can exist in a patent application. All right, so that's basically what a patent application looks like. All right, can you switch me back to my PowerPoint presentation?
You'll have to reshare your screen. So
Oh,
I just
okay.
unshared it, but just
Yeah.
as a heads up, we have 5 minutes as well.
Okay, I'll be finishing up here. Okay. I need to share again right here. All right. Okay, so What is a claim? A claim is the deed to the property. It needs to be written in legalized language. It has a preamble, a transition, and a body. You can have independent and dependent claims, all right? You refine an independent claim with adding elements to it or additional items, and you have to have it in clear and concise terms that are supported by the specification. You can't have anything that's not described in the specification in the claims. And each claim has to actually be a single sentence. I've written claims that have been 2 pages in handwritten form, but they all have to be in a single sentence presentation. All right, this is an example for a product claim for a bolt, where you've got a fastener for securing items to one another comprising, so this is the preamble, that's the transition, and then this is the body of the claim. All right, this is a dependent claim down here that depends on the first claim. Everything there plus whatever is shown extra. All right, examples of chemical claims, heterocyclic molecules having structures illustrated as compound 1, and then you have in a figure compound 1, a compound having the structural formula CXHYOZ, etc. So there are different ways of claiming. Another example, selenium containing hydrocarbon produced by, and this is a method claim where it's produced by isolating, mixing, purifying, mixing, isolating. These all have to be in gerund forms. You notice that they all end in ing, the beginning part of the claim. All right, patent application process, as I've gone through before, you document, keep in a lab notebook all of your invention information. You have a prior art search done that you conduct, because the first thing the examiner is going to do is conduct a prior art search. And then you have the application prepared, you submit the application is examined, and you either have an allowance or it's declined, and then you have to either appeal or do a request for a continuing examination. And then you have to, in the United States, pay maintenance fees. Every 3.5 years, once you have a patent issued, you have to pay to maintain the activity of that patent. All right, so that is the end of the material for today. Starting tomorrow, we'll be getting into, as it says here, copyright limitations and the exclusive rights for copyright.
Awesome.
Okay,
Well,
do I have any questions from anyone?
very good. Any questions from our audience here? I don't see any in the chat at this moment.
Okay.
Russell, I do recommend connecting with Raphael if you haven't already. It'd be a great resource to tap into for your classes around IP. Sorry to volunteer you, Raphael, but I know you're the expert in that space.
That's okay. Please do.
Awesome. Well, we're nearly at time. If there's no questions, I know there's a lot to digest there in our session 1. So thank you, Jim, for running us through that here. Oh, we do have one. How to get a patent and have a prototype built. I know you have experience in doing both, Jim, but I know we have just about 45 seconds. So if you feel like you have time.
In order to get a patent, in the United States, you can actually file a patent application on your own. There is a book called Patent It Yourself from Nolo Press that is a very good book. And when I used to teach patent law, I used to have the students use case books and also this book in the law class. It gives you all of the details. It tells you when you should have an attorney help you file the patent application. I don't advise individuals to file applications on their own because you're held to the same standards as an attorney. And that's not good when you're writing claims in particular. And then prototypes, that's a difficult situation. You need to have a qualified engineer who knows of sources for parts, machine shops, etc.
Now, if you don't have much money, if you go to our website, the OITT website, there's a page there about training that the U.S. Patent Office offers, and they actually have training where they teach you how to file your own patent application. I recommend you go see a lawyer, but the USPTO does give classes on how to file your own patent application.
I did have a client who wrote their own patent application, but then again, they had a PhD in particle physics and were very highly educated, and they wrote a very, very good patent application.
Yes.
But I've had other ones that clients have written that are not very good.
Yeah. Yes. Yes. If you have something simple, one example is the hula hoop. The whole patent application was only 2 pages long, actually 2.5 pages, I believe. And the first page was just drawings, cartoonish drawings. Now the hula hoop made millions and millions of dollars for Whammo. But if you have something more complicated, don't do it yourself.
So 2 quick questions. I know we're at time already. So one was just kind of the cost for filing a patent, which we kind of hit on a little bit, but and then if things change in the prototyping process, will you have to file again?
If you make significant changes in your invention, yes, you may have to file more than 1 patent. Generally, patents are written in broad terms, though. And so if you have a patent application, you usually put in there in the claim means for connecting. And then later on, you define that as being a bolt, welding, whatever it happens to be. Hopefully, you've written the patent application in such general terms that minor changes in a prototype won't require you to do a new application. But if it's a significant imaginative change, then you will have to file again.
Very good. Well, I think let's call it here since we'll have another hour to dive in tomorrow. So if you do have additional questions, be sure to note them, and we'll see you at the noon hour tomorrow for our second session. So thank you all for being here. Thank you, Jim and Raphael, for the partnership on this, and we look forward to seeing you all tomorrow. Alrighty, have a great rest of your day.
Thank you.
Bye-bye.